7 attorneys sat at the defense table. Behind them, 3 paralegals and 2 rolling briefcases filled with binders. The billing clock for their side was running at $9,800 an hour, combined. At the plaintiff's table, 1 woman, no attorney, no paralegal, no briefcase. Just a manila folder, a legal pad, and a pen she had borrowed from the court clerk because hers had run dry in the hallway. Her name was Dana Chamberlain. She was 33 years old, a single mother of 2, and she was about to do what every person in that courtroom believed was impossible: represent herself against the largest real estate firm in Houston, Texas, in a wrongful eviction case that 3 attorneys had already refused to take. Dana had been a paralegal for 6 years before she lost her job. She knew the law. She knew procedure. She knew how to file a motion, cite a statute, and read a contract. What she didn't have was $200,000 for a retainer. What she didn't have was a firm willing to go up against a billionaire on contingency. What she didn't have was time, because in 45 days, her family would be on the street. So she represented herself, and on the second day of trial, she said something. One sentence, spoken calmly in a quiet courtroom, in front of a judge who had been on the bench for 26 years, that caused 2 of the 7 attorneys to stand up, gather their files, and walk out of the courtroom. Not to recess, to quit, permanently. By day 3, a 3rd attorney had withdrawn. By the end of the week, the Billionaire's legal team had collapsed from 7 to 4. And the case that everyone said Dana couldn't win was already over. Because what she had found in the filings didn't just prove wrongful eviction. It proved a pattern of fraud so wide that 3 attorneys decided their careers were worth more than their client. Pause for 2 seconds and help me do something fun. Comment your city and country. I want to see how global this community really is. And I am looking for the 2 viewers watching the farthest apart today, so I can pin the winner. Now back to the story, because things are about to get very interesting. Dana Chamberlain grew up in 3rd Ward, Houston. Her mother cleaned office buildings at night. Her father drove a delivery truck until his back gave out when Dana was 12. They lived in a shotgun house on Dowling Street that had been in the family for 2 generations. Not owned, rented, but rented so long it felt like ownership. Dana was the first person in her family to attend college. She enrolled at Texas Southern University, majored in criminal justice, and graduated with a plan to go to law school. Then life rearranged her plans. She got pregnant at 23. Jenna was born in April. Dana deferred law school for a year. Then Morgan came 2 years later. The deferral became permanent. The tuition became impossible. The dream became a folder of acceptance letters she kept in a drawer. She became a paralegal instead. She worked at Garza and Reyes, a small civil litigation firm in Montrose, for 6 years. She drafted motions. She organized discovery. She prepped witnesses. She sat in on depositions and trials and watched how lawyers won and how they lost. She learned more about litigation from the second chair than most law students learn in 3 years of classes. Then the firm lost its largest client. Then layoffs. Then Dana was out. She found an apartment for herself and the kids, a 2-bedroom unit in the Sycamore Ridge complex, a 280-unit development in southeast Houston. The rent was $1,340 a month. She paid it on time for 14 months. On the 15th month, the building was sold. The new owner was Lockhart Property Group, a $5.2 billion real estate company controlled by a man named Murray Lockhart. Murray specialized in one thing: buying affordable housing complexes, raising rents to market rate, and converting the buildings into luxury units. The industry called it value-add investing. The tenants called it displacement. Within 60 days of the acquisition, every tenant in Sycamore Ridge received a notice. Rent was increasing from $1,340 to $2,680 per month, effective immediately. No negotiation, no transition period. Pay or vacate. Dana couldn't pay $2,680. Neither could 211 of the 280 families in the complex. They had 30 days. Dana went to 3 attorneys. The first said the case had merit. Texas Property Code Section 92.019 required 30-day written notice of rent increases above 10%, and the increase was 100% with no prior notice. But the attorney wanted a $15,000 retainer. Dana didn't have it. The second attorney agreed the eviction was wrongful, but said Lockhart has a legal team that buries plaintiffs. You'll spend 2 years in litigation and go bankrupt before you see a courtroom. The third attorney was more direct. Dana, I'm not going up against Murray Lockhart. Nobody in this city is. He owns buildings. He owns judges. He owns the process. Dana sat in her car in the parking lot of the third attorney's office. She called no one. She stared at the steering wheel for 12 minutes. Then she drove to the Harris County Courthouse, walked to the clerk's office, and filed a pro se complaint. Chamberlain versus Lockhart Property Group. Wrongful eviction. Violation of Texas Property Code Section 92.019. Breach of the implied warranty of habitability. She filed for herself and as class representative for 211 families facing the same eviction. The filing fee was $312. She paid it with her last paycheck from a temp agency where she had been filing insurance claims for $17 an hour. Subscribe now and stay to the end, because I am going to show you one document Dana found in the building's public maintenance records that Lockhart's legal team never expected anyone to read. And when I reveal what it says, you will understand why 3 of his 7 attorneys walked out of the courtroom. This is not drama. This is exposure, and we are about to break down exactly how she did it, step by step. Dana had 45 days before the eviction deadline. She used every one of them. She couldn't afford a lawyer, but she had been a lawyer's right hand for 6 years. She knew how to file motions. She knew how to organize discovery. She knew how to read a contract and find the sentence that didn't belong. She set up a workspace at her kitchen table, the same table where Jenna did homework and Morgan drew pictures, and worked every night from 9 p.m. to 2 a.m. after the kids fell asleep. First, she filed a temporary restraining order to halt the evictions. The judge granted it, a small victory that bought her an additional 60 days. Second, she filed a discovery demand. She requested every document related to the Sycamore Ridge acquisition, the purchase agreement, the rent schedule, the maintenance records, the inspection reports, the tenant communications, and all internal memos between Lockhart Property Group and the previous owner. Murray Lockhart's legal team, led by Victoria Greenway, a senior litigation partner who billed $1,400 an hour, responded with a motion to quash the discovery as overly broad and unduly burdensome. Dana filed her opposition brief in 48 hours. It was 11 pages, single-spaced, citing 14 Texas cases on the scope of discovery in wrongful eviction claims. She wrote it at the kitchen table. Morgan was asleep in the next room. Jenna was still awake, reading on the couch. "Mom, what are you writing?" "A brief." "What's a brief?" "It's a letter to the judge explaining why I'm right and they're wrong." "Are you right?" "Yes." "Then why do you need 11 pages?" Dana smiled. "Because being right isn't enough. You have to prove it in their language." The judge denied the motion to quash. Discovery was ordered. Lockhart Property Group was required to produce 4,200 pages of documents within 30 days. Dana read every page, not skimming, reading. The way a paralegal reads, every clause, every footnote, every signature block, every date. On page 2917, she found it. Page 2917 was a maintenance inspection report for Sycamore Ridge, dated 14 months before Lockhart purchased the building. The report was conducted by an independent inspector hired by the previous owner during the sale process. It was a standard due diligence document, the kind that buyers review to assess the condition of a property before acquisition. The report was 34 pages. It documented 147 maintenance deficiencies across the 280-unit complex. Broken fire escapes, non-functional smoke detectors, mold in 23 units, plumbing failures in the basement that had contaminated the water supply in Building C, structural cracks in the parking garage rated urgent, immediate remediation recommended. The estimated cost of repairs, $3.4 million. The report had been provided to Lockhart Property Group as part of the due diligence package before the purchase. Lockhart bought the building anyway. He bought it for $28 million, $3.4 million below the asking price. The discount matched the repair estimate exactly. He got a $3.4 million discount for repairs he never made. Instead, he doubled the rent. Dana cross-referenced the inspection report with the building's public maintenance filings, the records every property owner in Houston is required to file with the city's housing department. The filings showed 0 maintenance work orders completed in the 14 months since Lockhart acquired the property. Not one. No fire escape repairs. No smoke detector replacements. No mold remediation. No plumbing fixes. Nothing. He raised the rent 100% on a building he knew was unsafe and hadn't spent a dollar to fix. But that wasn't the worst part. The worst part was on page 2923. It was a memo from Lockhart's acquisitions team, addressed to Murray Lockhart personally. The memo summarized the inspection findings and included a 1-paragraph recommendation. Property requires $3.4 million in deferred maintenance. Recommend negotiating purchase price reduction equal to repair costs and completing remediation within 12 months of acquisition. Murray Lockhart's response was handwritten in the margin. 1 sentence. Use the discount, skip the repairs, raise rents to cover repositioning costs. He took the discount for repairs. He pocketed the discount. He raised rents on the tenants to cover the repositioning, the luxury conversion, while leaving the 147 safety deficiencies in place. The tenants were paying double rent to live in a building the owner knew was dangerous. Dana made 3 copies of the memo, 1 for her file, 1 for the judge, 1 for herself. She sat at the kitchen table at 2:14 a.m. and pressed her hands flat on the surface. Her heart was pounding, not with fear, with clarity. She now had 3 things: a wrongful eviction claim, a habitability violation, and a memo in the billionaire's own handwriting proving he knew the building was unsafe and chose to profit from it instead of fixing it. She whispered to the empty room, "You skipped the repairs. I didn't skip the reading." Real quick, pause and drop a comment below. Tell me if you have ever lived somewhere that was falling apart while the rent kept going up. Share your thoughts, because this community is built on people who know what it feels like when the building doesn't care about you. Trial Day 1, Harris County Civil Court. Judge Carolyn Walden presiding. She was 56, had spent 26 years on the bench, and had a reputation for running her courtroom with precision and 0 tolerance for games. Dana sat at the plaintiff's table, alone. Manila folder, legal pad, borrowed pen. Across the aisle, Victoria Greenway and 6 associates. 3 paralegals, 2 rolling briefcases. A billing clock ticking at $9,800 an hour. Victoria's opening statement was polished. She framed the rent increase as a market rate adjustment consistent with the property's repositioning strategy. She called Sycamore Ridge a distressed asset undergoing value enhancement. She called Dana's lawsuit an emotional response to a standard business decision. Dana's opening was short. She spoke for 3 minutes and 40 seconds. She did not use notes. "Your Honor, I am not an attorney. I am a former paralegal. I am a single mother of 2 children. I live in Unit 14B of Sycamore Ridge Apartments. For 14 months, I paid my rent on time. Then a billionaire bought my building, doubled the rent with no notice, filed to evict 211 families, and called it repositioning. But the building has 147 documented safety deficiencies. No repairs have been made. And the owner took a $3.4 million discount on the purchase price specifically for those repairs, and never completed them. I don't have an attorney, but I have the documents, and the documents say everything I need to say." Day 1 belonged to the defense. Victoria presented financial analysts, market comparisons, and a property consultant who testified that the rent increase was within the range of comparable luxury conversions in the Houston metro area. Dana cross-examined each witness with short, precise questions. She didn't argue. She planted seeds. To the financial analyst, did your market comparison include the building's current condition, the 147 documented deficiencies? I assessed the target condition post-renovation, the renovation that hasn't happened. It's scheduled. It's been 14 months. Can you show me a single completed work order? Silence. To the property consultant, you called this a luxury conversion. Are the smoke detectors in Building C functional? I didn't inspect the individual units. The inspection report says they're not. Would you call a building without working smoke detectors luxury? That's a maintenance issue, not a valuation issue. It's a safety issue, and the tenants are paying double rent for it. Day 2 began with Dana calling her first witness, herself. She took the stand. Judge Walden allowed it. Pro se plaintiffs can testify without examining counsel. Dana spoke directly to the judge. Your Honor, I'd like to enter Exhibit 14 into evidence. This is the independent inspection report from the due diligence package provided to Lockhart Property Group before the purchase. Page 1 through 34. 147 deficiencies. Mold, broken fire escapes, contaminated water, structural cracks. She held up the report. And I'd like to enter Exhibit 15. This is the internal acquisition memo addressed to Murray Lockhart. It recommends completing repairs within 12 months. Mr. Lockhart's handwritten response is in the margin. She read it aloud. Use the discount, skip the repairs, raise rents to cover repositioning costs. The courtroom shifted. A murmur spread through the gallery where 37 Sycamore Ridge tenants sat watching. Victoria Greenway's pen stopped. Dana wasn't finished. She looked at the defense table. I'd also like to direct the court's attention to the property's public maintenance filings with the City of Houston. In 14 months under Lockhart ownership, 0 work orders have been completed. 0. The discount was $3.4 million. The repairs cost $3.4 million. The discount was taken. The repairs were not made. The tenants are being evicted from a building the owner knew was dangerous and chose not to fix. She paused. She looked at the judge. Your Honor, I'm not asking this court to feel sorry for me. I'm asking this court to read the documents. Because the documents show that Murray Lockhart didn't reposition this building. He looted it. He took the repair money, raised the rent, and filed to evict 211 families from a building that isn't safe to live in. Then Dana said the sentence, the one that changed everything. She turned toward the defense table, not at Victoria, not at the paralegals, but at the 7 attorneys themselves, and said, I want to ask the attorneys at that table a question, not a legal question, a personal one. You've read these documents. You've seen the inspection report. You've seen the memo. You know what your client did. And every day you walk into this courtroom and defend it, you are telling 211 families, including my children, that their safety doesn't matter because your client can afford to make it someone else's problem. She paused. So my question is, how long are you going to keep doing this? The courtroom was silent. Judge Walden did not intervene. She didn't sustain. She didn't strike. She watched. Victoria Greenway stared at Dana. Her jaw was tight. Her hand was flat on the table. Charlotte Carr, the second attorney, slowly closed her binder. She looked at Victoria. Then she looked at the judge. Your Honor, I'd like to request a brief recess. Denied, Judge Walden said. We're in the middle of testimony. Charlotte stood. Your Honor, I am withdrawing from this case. Effective immediately. The courtroom gasped. Victoria turned. Murray Lockhart, watching from the gallery, leaned forward. Miles Sheridan, the third attorney, stood next. Your Honor, I am also withdrawing. I can't continue on this matter. 2 attorneys, gone, in the same minute. By the end of the week, Miles Sheridan had contacted Dana directly, not as an opponent, as a witness. He told her that Lockhart Property Group had used the same strategy. Buy distressed, take the repair discount, skip the repairs, raise rents, evict, on 11 other properties across Texas. He had the internal files. He was willing to testify. The case that started with one woman and a borrowed pen now had a pattern. 11 buildings, thousands of families, one billionaire, and 3 of his own attorneys standing on the other side. If you love your mom, you need to subscribe right now, because at the end of this video, I am revealing one thing that Miles Sheridan found in Lockhart's internal files that nobody, not even Dana, knew about. And when I show you which building is on that list and what happened to the family inside it, you will understand why this case went from a rent dispute to a federal investigation. Trust me, the secret is worth the wait. With 2 attorneys withdrawn and a third preparing to testify for the plaintiff, Victoria Greenway requested an emergency recess to reconstitute the defense team. Judge Walden granted a 72-hour continuance. During those 72 hours, 3 things happened. First, Murray Lockhart fired Victoria Greenway. Not because she was incompetent, because she told him the truth. Murray, if the inspection report and the memo reach the jury, you lose. If Miles testifies about the other 11 properties, you don't just lose the case, you lose the company. Murray's response: then make sure Miles doesn't testify. Victoria refused. She withdrew that evening. Second, Miles Sheridan met with Dana at a coffee shop on Westheimer Road. He brought a flash drive containing internal files from 6 of the 11 properties where Lockhart had used the same strategy. Each file showed the same pattern: independent inspection identifying deficiencies, purchase price discounted by the repair amount, repairs never completed, rents raised, tenants evicted. "Why are you helping me?" Dana asked. Miles looked at his coffee. "Because Charlotte walked out first. And when she stood up, I realized I'd been sitting down for 3 years. Every time I drafted a motion to evict a family from a building I knew was unsafe, I told myself it was the client's decision, not mine. But that's not true. I was the one filing the paper. My name was on it." He slid the flash drive across the table. "This is everything I have. Use it." Third, and this is the detail that broke the case open. One of the 11 properties on Miles's list was a building in Galveston called Harbor View Terrace. Lockhart had purchased it 4 years ago. The inspection report identified a gas line deficiency rated critical, immediate repair required. Lockhart took the $1.8 million repair discount. The gas line was never repaired. 14 months after the purchase, a gas leak in the basement of Harbor View Terrace caused an explosion that destroyed 4 ground floor units. A family of 3 was hospitalized. The father, a 41-year-old construction worker, suffered burns over 30% of his body. The 2 children, ages 6 and 9, were treated for smoke inhalation. The incident was classified as an accident. No charges were filed. The city's investigation found aging infrastructure as the cause. But Miles's file showed the truth. The gas line had been identified as critical in the pre-purchase inspection. Lockhart was notified. The repair discount was taken. The repair was never made. And 14 months later, a family nearly died. Dana held the file. Her hands shook. This was not a rent dispute anymore. This was negligence. Willful, documented, profitable negligence. Across 11 buildings, across 4 years. She called a reporter, Josie Sterling at the Houston Chronicle. She told her everything. She gave her copies of the documents, the inspection reports, the memos, the handwritten margin notes, and the Harbor View explosion file. Josie ran the story 3 days later. Front page, above the fold. Lockhart Property Group took repair discounts, skipped repairs on 11 buildings, families evicted, 1 nearly killed. If you are still watching, you are exactly the kind of person this channel was built for. Hit that subscribe button so you do not miss the next episode. Because this exact pattern of repair fraud and tenant displacement shows up in another billionaire real estate case I am covering soon. And the memo strategy Dana exposed here becomes even more important in that story. Murray Lockhart hired a new legal team. They attempted to settle. Dana refused. "I didn't file this case to get a check. I filed it so 211 families could stay in their homes. And now I'm filing it for every family in every building you looted." The trial resumed. Dana presented the 11-building pattern through Miles Sheridan's testimony. She presented the Harborview explosion file. She presented the inspection reports, the repair discounts, the 0 completed work orders, and Murray Lockhart's own handwritten instruction: use the discount, skip the repairs. The jury deliberated for 5 hours. They found Lockhart Property Group liable for wrongful eviction, breach of the implied warranty of habitability, and fraud. They awarded Dana Chamberlain and the 211 families $18.4 million in compensatory damages. They awarded an additional $26 million in punitive damages. Total, $44.4 million. Won by a woman with no attorney, a manila folder, and a borrowed pen. But here is the detail I told you to wait for. The secret that nobody in that courtroom understood. The reason Miles Sheridan had access to the internal files for all 11 properties was not because he was senior enough to have system-wide access. It was because, 6 months before the trial, he had been assigned to a quiet internal task: reviewing the company's exposure across all active properties for a potential IPO filing. Lockhart Property Group was preparing to go public. Murray wanted a clean compliance report. Miles had found the opposite. He had compiled a risk assessment showing $41 million in unresolved deferred maintenance across 11 properties, $14 million in potential habitability claims, and the Harborview explosion as an unresolved incident with catastrophic liability potential. He had submitted the report to Murray directly. Murray's response was the same as always: handle it through insurance, don't surface it. Miles had kept a copy. The IPO risk assessment was now Exhibit 31 in Dana's trial. It showed that Murray Lockhart had been informed, in writing, by his own attorney, that his buildings were dangerous, his tenants were at risk, and his legal exposure was catastrophic. He chose to bury it and go public anyway. The SEC opened a formal investigation into Lockhart Property Group's IPO disclosures 3 weeks after the verdict. The IPO was withdrawn. Murray's personal assets were frozen pending the investigation. The Harborview explosion was reopened by the Galveston County DA as a potential criminal negligence case. Murray Lockhart was not arrested. Billionaires rarely are for real estate negligence. But his company was dismantled. His IPO was dead. His name was removed from 12 buildings across Texas, and 211 families stayed in their homes, at the original rent, under a court-mandated affordability provision that lasted 10 years. Dana Chamberlain did not become a lawyer after the trial. Not immediately. She used her portion of the settlement, $340,000 after class distribution and fees, to do 3 things. She paid 14 months of back rent for 12 families in the Sycamore Ridge complex who had fallen behind during the litigation. She set aside enough for Jenna and Morgan's college funds. And she enrolled in the evening law program at South Texas College of Law. She started classes 6 months after the verdict. She attended 4 nights a week. She studied at the kitchen table, the same table where she had built the case, drafted the briefs, and read 4,200 pages of documents while her children slept. On her first night of class, the professor asked each student to introduce themselves and explain why they chose law. Dana stood. "My name is Dana Chamberlain. I'm a single mother. I'm a former paralegal. 6 months ago, I represented myself and 211 families in a wrongful eviction case against a billionaire. I won. I'm here because I don't want anyone to have to do that alone." The classroom was quiet for a moment. Then the professor said, "Welcome to law school, Ms. Chamberlain. I think you're going to do just fine." 2 years later, Dana was named to the Law Review. Her note was titled, "The Paralegal's Advantage: Pro Se Litigation Strategies in Tenant Rights Cases." It was the most cited student note in the journal's history. On the night she was published, Jenna, now 13, sat across from her at the kitchen table. Jenna was reading the article on her phone. "Mom." "Yeah? Remember when I asked you why you needed 11 pages to prove you were right?" "I remember. How many pages is this one?" 23. Jenna smiled. "I think you're getting better at it." Morgan, now 10, walked in holding a drawing. It was a picture of a woman standing in front of a building. The building had a sign on it. The sign said, "Dana's Law Office." "Can we build this?" he asked. Dana looked at the drawing. She looked at her son. She looked at the kitchen table that had held every brief, every motion, every exhibit, every night of work that had brought them from an eviction notice to a courtroom victory to a law review. "We already started," she said. Morgan taped the drawing to the refrigerator. Next to it, Jenna taped a printout of the law review article. Next to that, Dana taped one more thing: the receipt from the Harris County Clerk's office. $312. The filing fee that started everything. 3 pieces of paper on a refrigerator, a filing receipt, a law review article, and a 10-year-old's drawing of a building that doesn't exist yet. But it will. Murray Lockhart had 7 attorneys, 3 paralegals, $9,800 an hour in legal firepower, and a strategy that had worked on 11 other buildings. Buy cheap, skip the repairs, raise the rent, evict the families, and let the lawyers handle the paperwork. Dana Chamberlain had a manila folder, a legal pad, a borrowed pen, and 6 years of watching lawyers work from the second chair. He had the process. She had the documents. And on the second day of trial, she asked 7 attorneys a question that wasn't in any law school textbook. "How long are you going to keep doing this?" 2 of them stood up and left. A third followed. And the case that everyone said she couldn't win broke open from the inside, because the Billionaire's own team couldn't stomach defending what the documents showed. Dana didn't outspend Murray Lockhart. She didn't outsmart his legal team. She outlasted their conscience. She showed them the inspection report and the memo and the 0 completed work orders and the families in the gallery. And she asked them to keep defending it with a straight face. 2 of them couldn't. The most expensive legal team in Houston was defeated by a woman who couldn't afford a pen. Not because she was louder, not because she was angrier, because she had read page 2,917 of a 4,200-page document dump at 2 a.m. at her kitchen table while her children slept. And on that page was the truth that 7 attorneys had been paid to ignore. Some people think justice requires a law degree. Dana Chamberlain proved it requires something simpler: the willingness to read what nobody expects you to read, and the courage to say what nobody wants to hear. She said it. They quit. And 211 families stayed home. Click the video on your right to see the 3 other corporate espionage cases where self-representation destroyed billion-dollar companies, the legal loopholes they exploited, and the one statute that changes everything. You will see the patterns these strategists use, the mistakes their opponents make, and the exact moment when the trap closes.